All rise. The Court of Appeals Division 1 is now in session.
Please be seated. This is the time set for argument in our cause number 1CA SA230021, Kelly versus Blanchard, Goings, real party in interest. Counsel, we've read the pleadings in this case. We've discussed the matter at conference this morning. Both sides have 20 minutes to present their argument. I would remind petitioner that if you wish to have any time remaining for rebuttal, it's incumbent upon you in preserving that time. With that, as each counsel steps to the podium, if you'd please state your name and the party for whom you represent, you may begin.
Good morning, Your Honors. Christopher Robbins here on behalf of defendant petitioner Thomas Kelly. I will try to reserve at least 5 minutes for rebuttal. Your Honors, normally in the situation I'd be arguing why you should accept special jurisdiction. This is one of those rare cases when everybody agrees that we need the guidance from the court on the interpretation of a rule of civil procedure. In fact, since we filed the petition for review, our firm has seen an increase in the number of plaintiff's attorneys demanding the same type of conditions before a Rule 35 examination. In our briefs, I think we've outlined all of the factors that support accepting special action jurisdiction, so unless the court wants me to talk further on that, I'll just move on. Any questions? Okay, thank you. The court is much better able and much better qualified than we are to tell us the meaning of a rule of civil procedure, so I will hope to be guided by your questions. Rule 35 is not a weapon in either side's arsenal. Its purpose and intent is to level the playing field between personal injury plaintiffs and defendants. Plaintiffs can come to court with an army of treating physicians and treating providers. In fact, we often see plaintiffs referred by their attorneys to the same providers over and over again for the same diagnoses and the same treatments.
I have a question about the term like reports.
Yes.
Does that refer to reports from IMEs, or is it broader than that?
We don't know.
What do you think it is?
What I think like reports means is it says all like reports, and so presumably it means a Rule 35 examiner's reports of both IMEs and possibly even their patients, like reports of the same condition. But it doesn't mean that. It means it applies to one single person, the plaintiff, the person who was examined, the only person other than the Rule 35 examiner and the party requesting the examination that's mentioned in Rule 35. And what happens is Rule 35 gives a defendant the one chance to conduct an independent medical examination so that they don't have to depend upon the plaintiff's treating providers, treating physicians. It's that one single chance for the defendant to have somebody other than the plaintiff's hand-chosen, hand-selected providers come in and testify. Fundamental fairness demands that the defendant be given that opportunity.
Can you give an example or two of when a defendant would be in possession of like reports about a plaintiff?
Judge Kenneth Gregory suggested a couple possibilities if there were preliminary reports which may not necessarily be required to be disclosed. If, in fact, this claimant had, or this plaintiff had previously filed a lawsuit and been seen by this. I admit that it would be rare, and it's not, this may not be the best written rule, but we've all seen rules and statutes that are not pictures of clarity. What the rule does, though, is it says, defendants, as a matter of fundamental fairness, you should be allowed to come in here and present your own expert testimony regarding the physical or mental condition that's been put in controversy by the filing of the lawsuit. And then Rule 35D2 and D3 provide for the reciprocal exchange of like reports from those providers, both the Rule 35 examiner and the plaintiff's providers, as to the plaintiff who has been examined.
Is your client in possession of any like reports about the plaintiff in this matter?
I don't know, Your Honor. I don't believe so. I would guess not, but could be the situation. It's our position that under the plain meaning rule and every other rule of rule interpretation, the term like reports in Rule 35 refers to reports of earlier examinations of the same condition of the plaintiff.
Can go back just a second? Because you mentioned other preliminary reports, and perhaps you could just help me understand the IME process just a little bit better. Let's say that there's an individual that has a serious back injury,
Sure.
and that's going to need some tests. Now, I'm assuming that tests would have been done, but what if the IME doctor says, well, no, it needs to be the test, I want a new test that shows this. I haven't seen any tests that show this part of the spine, so I'm going to send this person to Simon Med, whatever, to have this kind of an MRI. Is that what you think is possibly like reports of the
I
same
think possibly.
condition?
Yes, Your Honor, I think possibly that's included.
Does that happen as a matter of practice, where the IME doctor would actually order reports? Do you think, I don't know.
I'm in this court much more often than I am down in the trenches. So I will tell you, my understanding is generally the Rule 35 examiner will not send a plaintiff out. It will be just a typical examination, like as if this were a patient presenting to the Rule 35 examiner. That's my understanding. I could be wrong.
Thank you.
But possibly, possibly if he says, well, he or she says, I need an X-ray. Maybe that is included in like reports because it is of the same condition of this patient, of this plaintiff. I'm not patient, plaintiff.
But you do agree that it is often going to be the case that the examining physician will have copies of like reports about other patients that had a similar condition, right?
That's more
likely to happen than the defendant having copies of like reports about the plaintiff.
And so, and here's the situation then, Your Honor. What Judge Blanchard required is that Dr. Hendon, who's a physician, a practicing physician, a neurologist in fact, Dr. Hendon says, I am not going to do this Rule 35 examination under those conditions.
Right, because he has lots of like reports about other patients that have a similar condition. I'm guessing that's why he's saying that.
Here's the thing. Well, he first of all, he doesn't have the time. He doesn't have the time or staff, and won't go to the expense of sorting through all of his previous patients and Rule 35 examinees to find like reports of the same condition.
Does he do a lot of IMEs? I mean, if the rule was narrowed to only like reports of IMEs, with this condition?
No, it's still impossible, Your Honor, because, I don't know, there might be some doctors, but most doctors are not going to keep a lawyer on staff to determine what are like reports of the same condition, to determine what that means, and more importantly, to redact the information in those reports. That's a tremendous time and expense, and doctors aren't qualified to do that. They needed a lawyer to do that.
It seems like we have a situation where we have one interpretation where the rule, as you've admitted, will rarely apply, and we have another interpretation where it will often apply. So why should we pick the rarely apply interpretation instead of the often apply interpretation?
Here's another important reason, Your Honor. A doctor, a Rule 35 examiner, is not going to risk the privacy of his patients and other plaintiffs, or the risk of a HIPAA violation, putting his license at risk. Doctors are not going to do that. The whole purpose, they've told you what their purpose is in their interpretation of this rule. Their purpose is to put a chilling effect on potential Rule 35 examiners. They've said that. They've said, we want to make this an arsenal, a weapon in plaintiff's arsenal. That's what the amicus said. That's what they said in their brief. That's not the purpose of the civil rules of procedure, is to add weapons to anybody's arsenal. The whole purpose is to level the playing field. The doctor who performs the examination produces his report. The plaintiffs then produce reports from their treating providers of this like reports of the same condition. It's perfectly level, and you know, we can't really add much to what Judge Kenneth Gregory said in the minute entry we provided. We can't add anything much to what the new decision in the Chef case, which fortuitously came out just at the beginning of last month. It says the purpose of the rule, the intent and purpose of the rule, as a matter of fundamental fairness, the examining doctor will produce a report, favorable or unfavorable to the party he's doing it for, will produce a report, and then the plaintiff will produce reciprocal reports from their treating providers so that we can decide cases on their merits. And so we can decide them justly and speedily and inexpensively. The rule says nothing at all, and nowhere in the rule does it mention any other parties, except for that brief one that the plaintiff can have a representative present at the Rule 35 examination. But other than that, it mentions three parties: the party requesting the examination, the Rule 35 examiner, and the plaintiff, the examinee. Those are the only parties mentioned.
And I understand and I sympathize with the privacy and confidentiality concerns, but those sorts of issues routinely come up in civil litigation, and superior courts, I think, are adept at handling those through protective orders and other mechanisms. Why is that not sufficient here with respect to Rule 35?
Because that's the plain meaning of Rule 35 addresses just those three parties. They want what they call like reports from doctors for the purpose of showing the bias and prejudice of the Rule 35 examiner. This court has already told them what they can do under other rules of civil procedure to do that and follow through with all of the procedures you were just talking about, Your Honor. American Family versus Grant said this is where the limitations are. I mean, plaintiffs want those like reports to show bias and prejudice, and the American Family versus Grant Court said, basically, generally, that is useless. I mean, the jury knows that the doctor being offered by the defendant is generally going to, offer testimony and opinions in favor of the defendant, that the treating physicians are going to offer testimony and opinions in favor of the plaintiff. The jury knows that. The jury doesn't need any more of that. But if the jury does, and the American Family versus Grant Court said that they do get to obtain evidence, but it's not under Rule 35. Rule 35 is the even playing field, and that's it. And then you can go and argue, under Rule 45 or Rule 26.1 or Rule 26. You can go argue under those rules, but Rule 35 is just simple and sweet. It says, like reports of the plaintiff. Your Honors, Judge Blanchard did not hold oral argument in the trial court, so we never had an opportunity to discuss the other conditions. There were 7 other conditions demanded by Ms. Going's attorneys. What we request here, Your Honor, is that the court vacate Judge Blanchard's ruling, order that Ms. Going submit to a Rule 35 examination with Dr. Hendon as prescribed by Rule 35. And we also ask the court to make clear that plaintiffs may not unilaterally impose additional conditions that are not contained in Rule 35. The rule is the rule. There's a simple, clear interpretation, in our opinion, that does justice for both sides. It provides fairness for both sides. It's a matter of fundamental fairness for both sides. It's not a weapon in plaintiff's arsenal. And so we ask for that relief, Your Honors. And I will save my remaining time for rebuttal.
All right, thank you, Mr. Robbins.
Thank you.
Mr. Abney.
Good morning, Your Honor. It's good to be here again. I pray before every oral argument that it will turn out well, and those prayers are rarely answered, but maybe today will be different. I am here today appearing on behalf of the real party in interest, Louisa Adele Maria Goings. I was up till 2 o'clock in the morning going over this, trying to parse all this out, and I'm stuck on the same problem everybody else says. What does like reports mean? I think we're limiting to examination reports. That is the subject of the rule, after all, physical and mental examination. So it should be limited to that and not just any kind of report you might have that you somehow got a hold of regarding the plaintiff. You do see occasionally IMEs performed on defendants. For instance, if your position is that the defendant driver had some sort of medical condition that caused or contributed to the accident, you will see an IME report of that kind. I did personal injury work directly instead of just appeals for a number of years, especially out in Mesa with the Skousen law firm. And I think every law firm has a couple of unlucky souls who get involved in accident after accident. They're not staging them. They're magnets. They're sitting at an intersection, they get rear-ended, and a year later they're sitting at an intersection and get rear-ended. So you can't have multiple IME reports of the same person. It's not unheard of to have that happen. In fact, I think everybody has that repeat sort of claim where they're not faking it, it's just bad luck, and you have to be examined again.
But how would a defendant come into possession of those prior IMEs or be in possession of like reports of similar conditions?
You put in a request for production of documents, and I often see that. Have you ever been examined before? Have you been involved in any previous accidents, any previous conditions? If so, produce, and then they'll see a request to produce any earlier IME reports. And you can either produce, the client either has them and you can produce them, or you identify who conducted the IME, find out from the client, and you tell the defense, and then you will participate in making sure that they get the document, as long as it's available. The trouble is you get a lot of doctors who have a very lucrative practice doing independent medical examinations, and you will see the same sort of report over and over. It's a form of bias and prejudice, I suppose, that they're sort of doing, they're doing these cookie cutter reports that are very similar. In fact, in my practice, I've run across several occasions where you get an IME report on John Smith, and most of the report talks about John Smith, and then Jane Doe starts showing up here and there from an earlier report.
Isn't that great fodder for cross-examination?
Well, sure, that is.
Yeah.
But it would be much more effective if you could get a selection of the report reports of like, what do they call this? Like reports of the same condition. There's always going to be some things to iron out. For instance, how much time, who's going to pay for a weeding process. You have to reach some sort of negotiated agreement of what a like condition is. If you can't do that, they're going to have to get a judge involved as an umpire or referee to figure out what is a like condition. The number of reports would always be a concern because people like Dr. Hendon, I think I saw a figure of 600 reports. I'm pretty sure he's done a heck of a lot more than that over his career. We don't want 600 reports. What would you do with that? And the parties here negotiated down to a certain number of reports that they were going to get. And then I think somehow the roof fell in and everybody started disagreeing, and we wound up with the motion and the result that brings us here today. As far as what like reports mean, a similar condition, work out a negotiated idea of what that is, and work out the mechanics of how you're going to do it. Confidentiality is always a concern. That can be worked out. You see that orders on that all the time, confidentiality and protective orders. I do not think that HIPAA is a concern because there is an exemption in HIPAA for producing reports in accordance with a court order. And Rule 35, you can get a Rule 35 order saying, produce.
But wouldn't the third party have standing to come in and complain about the disclosure of their report?
Yes. Yeah.
So
If they
you said
found out
that
about
Dr.
it.
Hendon had 600, so you would have to notify all 600 people that their reports may potentially be disclosed, and then they have to come in and make some type of record or objection, or in order to, because I'm not sure HIPAA apply. I agree with you, it says pursuant to a court order,
Right.
but I think before the court issues that order, there has to be some type of ability for the person to.
I don't think so. I think these medical reports are produced, for instance, for statistical and research purposes all the time, and the information identifying a particular person is simply redacted out. And you could do that and we do it with medical records that are produced. We always redact out identifying information that can be used, like a social security number. Those are gone. Addresses, they're redacted out. Personal identifying stuff is taken out that might be used against that particular person. We do that all the time in routine production of medical records. So
What if
I
it's
don't think you have to get
what if
permission.
it's an extremely rare condition? Like 10 people in the United States have it.
Well, that'll make the job of producing
It'd make it
reports quite
easier, but
simple.
it'd also make it really easy to identify who those folks are.
Well, I think we're sort of wandering into Gregory House territory here, these kinds of rare conditions. It's not lupus, we know that, of course.
But it seems like with this, let's back up. Is this rule ambiguous?
Ambiguous is all get out, as far as I
Okay, so where does that take us? It seems like you're saying, well, we got to put this condition on, you got to put this condition, you got to decide all these conditions, and like it seems like you're asking us to write a new rule.
No, I'm asking you to do what all the appellate judges I ever run into tell me to do, interpret it in context. And in the context of a discovery system that is aimed at proportionality and cost effectiveness, efficiency, and justice for all the parties, you need to come up with some sort of idea of exactly what is a like report, how many have to be produced, who's going to be paying for any screening that needs to be done above just a doctor leafing through, say, oh yeah, this is it. And if it's more complicated than that, somebody's going to have to pay for it.
That makes sense, but it seems like the right body is upstairs to rewrite the rule.
Oh, no. Well, I suggested to my esteemed colleague across the aisle, who I admire immensely, that what you need to do is actually put some more words into this to make it simpler. To say, like reports of the same condition concerning the person examined. Just put in a few extra words to make it clearer. And occasionally you have to do that. You have to be longer to be shorter as far as meaning.
But Jen, assume this was a statute, council. Why would we be doing this if this was a statute? We would tell the legislature, guess what? It says what it says. We don't rewrite statutes. We just simply don't. That's not our role. And go figure it out, parties. I mean, here's what we think it says on its plain language, and then move on.
Well, this court not only has the courage and the intelligence to interpret it, it has the duty to interpret the rule. We have reached an impasse here. Nobody's interpreting this the same way, and so it falls upon this court to say, placing this in context and how the rules of discovery are supposed to work, this is what it means as far as our understanding is. Like reports means of the same condition mean the reports that can be identified of the same condition, not just for the person who's being examined, but for other people who have been examined by this particular doctor. And then you produce those, but then again, you do it in context. You want to do it in a proportional way, cost effective, that's not burdensome, overly burdensome to any party.
Looking at the language, D3 also says like reports of a similar condition when talking about what the party being examined has to disclose.
Right.
That term clearly is referring to like reports about the party being examined.
I believe
So D3, that phrase means about the person being examined. D2, you're saying that same term means about all other individuals who have been examined by the physician. So it seems like we have the same term shifting meaning from D2 to D3. Am I wrong about that?
Partially. I think there's a possibility that you could have reports in your possession and control of other people who have been examined. You might have those, and then you would have to produce them. I think the rule's broad enough, the subpart, D3 subpart is broad enough to cover that. So I know like reports is used twice, or several times here, 3 times at least. But I think it means of the same condition of any particular party unless the context requires otherwise. And in the context in D3 would require otherwise, I believe.
So you're saying in D3 there may be situations where the person being examined has like reports about other patients of the same doctor?
That's possible, or that person's representative. The lawyer representing that person may have like reports. Maybe that's what it's supposed to cover. I don't know for sure. I mean, the ambiguity in this thing is massive. But if it's going to be ambiguous and it needs to be construed, I think it really needs to be construed in a way that is broad enough to fulfill the purposes of the discovery rules. You want to get the information to the parties so that they do have a level playing field. As I started to say before, and
how is your interpretation consistent with leveling the playing field?
The plaintiff will have a better opportunity to prove to the trier of fact that the examiner is or is not competent, or is not biased or prejudiced. As I started to say earlier about why this is important, you're trying to show, more than anything else, I think, that the examiner is doing the same thing for person after person after person. They're getting the same report. There's no injury, or there's a slight injury. And in the same words, the same outcome, time after time after time, with no variation at all. And I think that reflects on the professionalism and the competence of the examiner. If it's just simply doing, okay, we've got Jane Smith in, let's pull out the Jane Doe report, change the names, a little bit about what was examined, poof, out it goes. And that's not what you're supposed to be doing in an independent medical examination as a medical professional. You're supposed to be looking very carefully at the physical and mental condition of a particular person and coming up with a very individualized report about that person. You're not just supposed to be shuffling names around. And we, as the plaintiffs, speaking somewhat on behalf of the plaintiffs bar, and based on general experience, that's what happens. You get some people that are very, very good at doing these reports. and are very good witnesses. They're tested in trial and tested in depositions, and they produce these reports over and over, and they're the same thing every single time. And it would be wonderful to show that the jury, get the person on the stand and show the jury, well, didn't you just do this report? It's identical, isn't it? And go on and on with a few examples of that kind, which should prove fairly conclusively to the jury that they shouldn't trust that examiner.
Right, Rule 35 says that the party requesting the examination is the one that is supposed to disclose the like reports.
Right.
It doesn't say that the individual performing the medical examination needs to, and it seems like your interpretation is taking a step from the party requesting the examination and putting a burden on the individual doing the examination. If you want something from the doctor performing the examination, why not serve the doctor with a Rule 45 subpoena requesting all prior reports?
Well, the doctor would, there's a couple of things. The doctor would say right off, hey, what authority do you have? And you say, Rule 35, because you were the examiner. So you circle right back to Rule 35. But it says, may request the examiner's report, like reports of the same condition. So you request those. And if the defense lawyer cannot come to some sort of agreement with the doctor, as apparently agreement was reached in this case to produce a certain number of reports, if you can't come to that sort of agreement with the doctor that you've hired, then you may have to do the subpoena route in order to get it from the doctor directly. And I think Rule 35 would give you the authority to do that. If you're wanting to get like reports and the defense lawyer is unable to get them voluntarily from the examiner, then I think you'd have to get them from the examiner. But you would go back as your authority and basis for doing that to Rule 35. I don't know where else you get the authority to do it. But I mean, this is an important issue, and I agree with my colleague that this is a suitable matter for this court to take up, and as an important enough matter that whatever you do, I hope it's favorable to my client, but whatever you do needs to be, if I may recommend, a published opinion. There's no other appellate court that I've located in the nation, and maybe my colleague has identified one by now, but that has ever dealt with this. And you can understand why. It's one of those issues that evades review because it all gets settled at the trial court level or at the district court level in the federal system, which is where we're seeing a lot of action on this, well, some action on this. But it never percolates up to the appellate courts. Well, here it's percolated in a very rapid way thanks to the petition for special action. So it's an issue that really needs to be resolved.
The few federal courts that have addressed it, this is similar to the federal civil rule, correct?
I think it's identical, if I remember.
And the federal courts that have addressed it have taken a much narrower view of it, haven't they?
Some have, and the one that's published that I know of hasn't. So there's a split. And while I admire the federal system, a lot of these are simply orders as you're going through the case, and the district court judge decides which ones they're going to tell Westlaw, publish this one, don't publish this one. So, I mean, it's what you have for authority is pretty weak here. This would be a groundbreaking opinion. Let's see. Oh, as far as new tests.
Looping back to my prior question, can Mr. Kelly say, well, I'm not, the rule says that the party that requested the examination has to disclose like reports, and I'm just not in possession of any of those.
If the doctor says I'm not in possession?
No, Mr. Kelly, who's the party who is requesting the examination.
Oh, then we deal with it from there. We say, oh,
with a subpoena to the doctor?
Oh, one more time, Your Honor?
You would deal with it from there by serving a subpoena on the doctor?
Yes, I believe that's, I don't know what else you can do. If Mr. Robbins can't resolve it with his IME doctor, then you would have to deal directly with the doctor. Through a subpoena, but then again, when the doctor says, oh yeah, then you'd say it's Rule 35.
Well, wouldn't you say it's Rule 26, which says I'm entitled to discovery of anything that is relevant? And the prior reports from this physician are relevant because I might be able to use them to cross-examine the physician at trial?
And Rule 26. Yes, I mean, if you were sitting down to actually draft this, you would find every rule on the planet and put it in there. But Rule 35 would be number one in my mind, and then Rule 26 is fine. And of course, the vessel for doing this would be Rule 45. I think you could do it, but Dr. Hinton doesn't want to do it. And I think justifiably so. I have my suspicions why, and I've already talked about those, and I don't want to get into some sort of slander lawsuit here, but, well, I will. I think he's produced cookie-cutter reports, and I think he doesn't want to show that, and that's why there's such tremendous resistance from him. As far as somebody asked about other examinations, like MRIs and whatnot, IME docs don't do that.
Never.
I don't think so. I think I remember way back in the past, I remember one IME doctor wanted to have some sort of nerve conduction study done. And it has some dangers to it. Damaging the nerve, for one thing, nerves. And the plaintiff said, no way, Jose, and he didn't get it done. But even an MRI has problems. If you happen to have any sort of piece of metal inside your body, it'll go right out and cause tremendous damage. So, an X-ray has problems because you're loading up your body with radiation. So they don't do it, no. I think that privacy concerns can be dealt with. I believe I dealt with that. We're not trying to weaponize anything. I mean, it's a great term, and I admire my colleague's eloquence, but we don't want to weaponize anything. We simply want to find out if this doctor has been producing very similar reports, and if so, why. And if there is something there that can show a pattern of practice of simply using the same report over and over and over, I think that would go to the quality of the examining doctor. It would be a very interesting thing for the jury to find out. I've run through everything I could think of that was raised. And
All right, thank you, Mr. Abney, for your argument.
thank you very much.
Mr. Robbins, any final word?
Thank you, Your Honors. First of all, there were no negotiations in this case. There was no agreement, nothing. They made a demand, we objected, and now we're here. Each of the judges has asked a great question. Judge McMurdy, we're not going to give notice to 600 potential people and get them involved. Judge Brown, we're not going to rewrite the rule. The rule admittedly could be susceptible to two meanings, but we're going to look at the one that makes the most sense, which is that the like reports refer to the plaintiff. Judge Catlett, what I took you to say is our plaintiff's providers also going to have to produce these reports, and I don't think they want to open that can of worms. They have these reports already. The plaintiff's bar has these reports. They have a library of the reports from most of the doctors who regularly perform Rule 35 exams. We don't want to get the court involved. We want the rule to be simple and straightforward. Produce like reports of the same condition regarding plaintiff, period. We don't have to go in and negotiate. We don't have to go in and look up the time and expense. We don't have to raise the court about what like reports means. We don't have to talk to the court about protecting privacy. We don't have to get the court involved at all. The parties don't need to negotiate. The rule is clear. And I find it very interesting that the rule says all reports, but now Mr. Abney says, well, not all reports, maybe just IME reports, and maybe just some reports. It's like, it can't be both ways. Rule 1 says that the rules apply to achieve a just, speedy, and inexpensive determination of the case. And the only way to do that is interpretation of Rule 35 as we have set forth in our briefs, and as the Chef Court set forth, and as Judge Gregory set forth. That's the only way to do it. Thank you, Your Honors.
All right, thank you, counsel. The matter is deemed submitted. We'll issue a decision in due course. Court's at recess.